Okay, guys, so here's the deal. We are live now. We're going to be answering disability questions. That means Social Security disability insurance, supplemental security income questions for basically the average person that says, hey, I've got a question. What do I do? I need an attorney to figure out the answer. So you call in Tuesdays and Thursday nights, right? Tuesday and Thursday. I go live. Sometimes it's at 8 p.m. Sometimes it's at 10 p.m. Sometimes it's at 1 a.m. But the bottom line is I go live. You call into the law firm phone number, right? The 407. I'm going to type it into the chat area right now, 279-1754. Okay, right there. Perfect. Now, what happens? When you call in, I answer your legal question, but a couple of basic rules you need to keep in mind. Number one, use a fake name throughout the process. Number two, very simple, have your legal question ready to roll. Number three, no story mode whatsoever. No story mode whatsoever. And the final thing is you get about 5 to 7 minutes per phone call. So with that said, Betty Bath, thank you for the mega donation. That's absolutely amazing. Betty Bath did the $20 donation. Thanks for being you, which is awesome. Love the pair with a little happy mirror. Very cool. Very, very cool. Love it. So we've got the first person on the phone right now to go ahead and ask their legal question. Good sir, using a fake name, what is your legal question? Go ahead.
So in the process, I've been denied my reconsideration on my SSDI. I was approved right off the bat for SSI.
Mm-hmm.
Apparently, part of the reason that, my medical is supposed to be the same for both, from what I understand, but they're saying that my medical is the reason I'm not getting SSDI. And it turns out my psychiatrist didn't turn in any paperwork. So my question is, I was looking at getting an attorney, and he said that they get 25% up to $7,200. And then in September, it's supposed to go up to $9,500. $9,200. And so the way he talked about it, though, was that he thought that, he would be able to get the $9,200 even if we signed the paperwork now.
Correct.
And so I thought that, if we signed the paperwork now, then it would be under the rules now, kind of like Social Security. But am I wrong?
No, it's going forward kind of gig. So basically going forward, the attorneys will get a raise because they've been so poorly paid for so long that a lot of them jump ship, and they're trying to save the industry so that attorneys stay in the game, because one of the big issues is that disability attorneys make it a lot easier for the SSA to process claims because they get all the forms in, they get everything completed, they line up all the stuff and make sure all the housekeeping stuff is all completed. Motions submitted makes it easier for the judges to rule on the claim. They organize it, they brief it, all that stuff. So they're not entirely in love with the idea of starving out the attorney pool. An attorney's supposed to be making per claim around $10K, so they bumped it up to $9,200. But bottom line is, if you were medically approved for SSI but not SSDI, then there's a major problem where somebody did something wrong. So what is your DLI?
What?
Your DLI, date last insured?
It's June of 2028.
June of 2028. So how can they say, and keep in mind, because the SSI earnings limitations are much more strict than the SSDI. So what specifically are they saying didn't go right for you to be approved for SSDI benefits? Or did you receive a special early approval for SSI and they're just catching the SSDI benefits up?
No, I had to go through all the hoops of going through SSI. I had to go to all the doctors and psychiatrists and everything for that.
Mm-hmm.
And it took me, we filed for that in June of 2021.
Mm-hmm.
I got SSI May of last year, and I filed for reconsideration because I never knew that I got turned down for SSDI because I was homeless at the time. And so I filed for reconsideration, and they said that they're turning me down for reconsideration. So now I'm supposed to go before a judge. I think this is the next step. I really wanted to hire you, but I'm in Charlotte, North Carolina, and I don't know if you cover us or not.
Oh yeah, I work in every I have claimants in every state pretty much at this point. So and the possessions of the United States as well. So with that said, let me ask you this. All right, so you can't see into the ERE, so you can't see why they're unhappy in the DDE document. You're appealing into the OHO ALJ level. When you were approved for SSI benefits, at what stage were you approved, and what do the approval letters say specifically for your impairments?
It was an initial attempt. I haven't ever been turned down for SSI, so it was an initial attempt on SSI. it said that due to medical reasons that I was approved for SSI. I have a bunch of, I have rheumatoid arthritis. I'm 57. So I have, a bunch of medical conditions and then have some psychological issues too. So
there's a problem here. What the attorney is likely going to do is go through and see where they made a clerical error, fix it. Now, remember, though, a lot of the back pay has probably already been paid out to you, and you're getting a check going forward. So this
is my SSDI?
Well, your SSDI is going to go ahead and tap into retroactive benefits going farther back. So this attorney is just banking basically on retroactive benefits because your going forward pay on SSI is a lower amount. So you can only get a little bit of back pay, and then he's going to be mostly tapping into retroactive benefits because you're already receiving your forward pay each month, which is counted against any potential back pay that attorney would be able to get.
So they can tap into your forward pay as well as your back pay?
Well, they're tapping into, all right, so this is complex, so I'll try and summarize it as best I can. SSDI benefits have access to retroactive benefits, which means before you filed for disability benefits. The attorney is going to try and tap into those. And then for each month that you received SSI benefits and back pay benefits, the attorney is going to try and tap into the little bit extra that that you could have gotten on top of basically the SSDI benefits. They're going to tap into that additional amount to tap into basically what you could have gotten on top of that. But most attorneys wouldn't take this claim because you're already receiving SSI and there's not much back pay / retroactive benefits that they can tap into with it because you already have an SSI approval.
Okay. So from what I understand, what you're basically saying is right now I'm getting $943 a month for SSI.
Mm-hmm.
And if it were going to be SSDI, then it would be like, we'll say $1,300. So that's $400 difference. So 4 times 36 would be, I think it's 14,000 is what my math came up with. And they would only get like 3,500 out of the 14,000 because they only get 25% of whatever I get up to 7,200. Is that right?
Whatever new money is coming onto the table from the SSDI benefit approval, including the retroactive benefits, they'd only get 25% of that, which is why, frankly, I would have rejected the claim because there's not enough money there to work the claim, spend all the money on the claim and get them prepped, write the brief, and then go do the hearing. There's just not enough money there. So in this case, this attorney is probably taking this thing on, not likely to do much prior to the hearing because there's not enough money to pay the attorney to actually spend much time with you.
Well, the attorney said that he would get 25% plus the fees to get the medical documents together.
Yep, the costs. Yeah, some attorneys charge more for that. But, remember, if he's buying HIPAAs or if he's using high techs and stuff like that, the costs are probably under $100. So, the reality is the attorney's not really making much to do much with this thing. So if you don't have much contact with this attorney, like, just to be fair, he's not going to be able to make much off of it either. So it's not, one of those situations where there's big money. Because remember, cutting into each month of back pay that he could potentially get as an attorney is your forward pay that you're receiving each month. So 943 doesn't count because you're already getting that in your forward pay for SSI. So there's just that little bit more, $400 on the SSDI benefits per month that he's going to get 25% back pay from, which isn't much. It's, what I mean? That's part of the problem with disability benefits that starves the disability attorneys. We just don't make that much per claim, which is why these big box lawyers and giant insurance groups, they're cool with that because they'll sign you up and then they'll just let you sit until you hit a hearing.
Okay.
Yep.
So you wouldn't take my claim if I tried to get you to hire me?
I probably wouldn't, but to be fair, good sir, we have so many callers per day looking for representation. We are.
Well, I understand.
Yeah, we're picking. Yeah.
Well, I've watched a bunch of your videos. I mean, I've been studying. I've been listening to a lot of stuff. I probably watched at least 3 or 4 dozen of your videos in the past week because I've been studying on this so that I know more about what I'm doing. Excellent. I think the attorney that I spoke with was surprised at what I did know because of the fact that I've been watching you on YouTube.
I get some attorneys that sometimes are pissed at me because the knowledge level of the claimant is much higher now than it was 15, 20 years ago. So the attorneys don't receive the same level of knowledge respect that they used to, which I think hurts the attorneys' field and the ability to make money. The other side of the coin is it's just easier to win disability benefits when you have the claimant learning and the attorney directing. When the attorney goes through the medical records and says, you're doing this, stop that. You're doing this, keep doing that. It rolls it forward more when you have a more strong base knowledge net, because that base knowledge is like a concrete structure that they can build more knowledge on top of. So I always looked at it as a good thing, because you can get somebody much farther with knowledge, learning what they need to do, what they need to not do. But other attorneys that don't want to do that much, they're worried because the little things, they used to make a lot of money off of that. But let me do this, though. It is 11 minutes in. I will catch you later, and you have a wonderful, wonderful night.
Yes, sir. You too. Thank you, and thank you for your time, sir. I appreciate what you're doing.
Absolutely, good sir. Have a wonderful night. Thank you so much. Bye-bye.
You too. Bye.
Hi, this is Attorney Walter Hnot, Disability Resolution PA. How can I help you? Oh, we got a phone thing that didn't work. We'll just wait for the next call. We shall see how many seconds it takes. 1 second, 2 seconds, 3 seconds. I guess it's going to take more. Let's see if we get somebody else calling in. Hold on. Boop. There we go. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. How can I help you?
Oh, wow. That's crazy. So I had a question. I'm on the left coast of the state, and I have a son that has severe autism. Right now, SSI is not going to cut it first. I have to do more than that. When he turns 18, how do I go forward with that if we find out we have to move out of state or anything of that nature?
I mean, if you got to move out of state, you just go ahead and notify the local field office that you're moving to, that you've moved to that new general location. So you go to the Google website, type in SSA field office finder zip code. Your SSA website will pop up. You click the, go ahead. Yeah.
Is there a different program than SSI that I could get him into at that point? I hear you guys talk about disabled adult children, and I was just trying to see how to go forward with those people beyond the SSI thing.
Yeah, so basically the child could go into disabled adult child benefits if they're between 18 and 22 and their parent is disabled, retired, or deceased. So, I mean, that's an option. But for the most part, it's one of those situations where they do have county programs and state programs, but the federal program is the main program with the $943 for SSI. But I mean, are you currently disabled, retired? You're obviously not deceased, so are you? Yeah.
No, not myself. I'm trying to do the best for my son, who is the disabled one, and he's adolescent right now. But once he turns 18, I understand that my resources aren't tied to him at that point. So then, can he get his own disability at that point, or how do I approach them at that point?
I mean, you got two main options here. You can see if he can go into an auxiliary program. You just go to the SSA website for that as well and see what other additional programs he could fit into based off of his parents, based off of his current situation. The other option is you could go ahead and basically, see if the child has any capacity for work and maybe do a ticket to work program. And that depends on with autism. Autism, you could be severe and then kind of grow to the point where you're able to have functional ability to do a basic job. And then when you do the basic job, you can earn some additional money on top of that. So seeing if there's like a ticket to work program option for the child to go ahead and grow out of the current benefit system that the child has. With that said, I mean, how much? What is the child's current age?
He's 13 at the most.
Okay, gotcha. So
being that we're from the Bay Area, the San Francisco Bay Area, $2,000 just doesn't cut it, as far as the limit for the SSI. So I basically told him I'm cool with that. But now I'm thinking about, once he turns 18, what program do I approach him with? Because I don't want him to get funneled back into SSI.
Well, I mean, he's always gonna have that as
me.
Yeah, he's always gonna have a background of SSI. I mean, DACs are something that gets added on top of SSI. It's SSI is always his background, his base. Yeah.
Okay, so at that point, after he turns 18, are my resources deemed?
No.
At that
Unless the child is, basically still in school up to essentially 22 and under direction of the parent. But no, SSI benefits, for the most part, at 18, they stop the deeming and they switch the child over from the 3-step sequential process over to the adult 5-step sequential process. But if the child already has benefits, then it would, of course, be the 8-step sequential process to see if the child should keep them. But what I would say is this. I don't know, because keep in mind, in California, SSI benefits get a boost. Like if you move to another state, those SSI benefits are going to drop.
Well, I dropped SSI because right now the state and county is more beneficial to our situation. So I just kind of told them, don't send me no more checks. But then I'm thinking at 18, when he turns 18, I doubt we'll be priced out of the area by that time. He may have to go back on a federal program, and I'm trying to figure out what would be what do I ask for? Because if you don't ask the right questions, you don't get the right answers.
Wait, so why would you bump the child off of SSI benefits? You're supposed to be able to get those.
Just because right now my resources are too high. Through
how high?
Enough.
Well, what are you earning per year?
$2,000. The rent's $2,000. I'm earning about 40 right now.
40? Man, just do deductibles off the child's cost of living adjustment so that you can get the deeming below basically 35-ish and still get your SSI.
Oh,
Use deductibles, yeah.
Okay.
Because remember, now he doesn't have Medicaid. I mean, he might have Medi-Cal, but, bottom line is, that health insurance that's worth something,
Right. Because we do the in-home supportive services. So I it's like they make it to where I gotta have more than 2,000 in the bank account at any time per month. That's just what it costs to live out these days. So SSI, just with the whole overpayment confusions and stuff, it's stressful. So I was just curious about once he turns 18, if I should be asking for the disabled child allowance, or if he gets his own SSDI.
Yeah. Any and all available programs. But remember, a lot of these programs are caps. They're not like stackable, but they're caps. You put the other one on top of the other one. So, but yeah.
Okay, I see.
Yeah, you're going to definitely
All right,
answer.
I'm going to let you go, brother. Yeah. I appreciate everything you do for us.
Absolutely, good sir. You have a wonderful, wonderful night, okay?
You as well.
Thank you,
Thank you very much.
Thank you. Bye-bye. Oh, shoot. I hit the person was just calling. I hit the wrong callback. I'm sorry. I hit the wrong button. Here we go. Hi, this is Attorney Walter Hnot. We are live on YouTube. Let me see what we got here. Hold on. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hi, this is John Smith. I have a question. I had my hearing with the judge on December 8th.
Okay.
And I was not approved, and I appealed with my lawyer, and the appeals council denied me. My question is, I was going back and looking through my denial letter again, and I noticed that my worst condition I have alleged on there, which is a connective tissue disorder, hypermobile Ehlers-Danlos syndrome. I noticed that they were referencing listing 14.06 for that. And when I looked that listing up, that listing, even though it says connective tissue disorder, it's specifically talking about autoimmune ones. And mine is not autoimmune.
Okay.
And after looking through a bunch of the listings on my own, I found one listing 1.18 that I think I meet all the criteria for, aside from my cane isn't prescribed to me. But my doctor would do that for me. Assuming that that my doctor did prescribe that to me, and assuming that I did meet all the criteria, is it, if I were able to find someone to represent me on the federal level, is it already kind of set in stone that we've already tried for 1406, or would we be able to try for 1.18, or what do you think?
So, I mean, the first thing I would say is if a listing was more proper than the one that was used for the analysis to do the elemental review, that could always be brought up. And if it was just a clear, better fit, that would be normally a good appeal ground for appeals counsel to go ahead and swap it over and make it happen. Now, with that said, you would look to essentially district court going forward as to the next spot on your trip. What did the attorney that you currently have say about basically going to district court?
He recommended that I start over. When I brought up that listing thingy, he was telling me that even though that looks good on paper, and he takes my point, that the judges have so much discretion that it doesn't really matter if he doesn't want to approve me.
Well, I mean, that is not inaccurate. The judges have a lot of discretion with how they feel the evidence applies. You went to appeals counsel agreed with the judge, and I'm sure you brought this issue up during the AC review.
I did not. I didn't notice any of this until after.
Okay, gotcha. Okay, so you have a trial tactic question in front of you. Do you want to wait potentially 15 to 16 months to try and get a remand back to AC, which will then remand with consolidation back to the ALJ, which will take probably 20 to 24 months to get in front of that same judge again? Or do you potentially want to go ahead and get another decision in somewhere around 15 months at the DDS level? Yeah.
That's the real heart of the question, isn't it?
Yeah.
Because I originally applied in February of 2021, so I feel bad losing out on back pay, even though that's very secondary as far as my priorities. I just need to be approved. So do you really think it would take that long with the federal case?
Well, it depends, because remember, with the federal district, you write a brief and then combine that brief for submission, basically with the attorneys on behalf of the SSA commissioner, and that gets submitted to an adjudicator that then makes a review to decide whether or not this claim should be going forward. In my opinion, what I think is realistically going to happen with your situation is that you're going to have a hard time finding an attorney to take it up to that level, unless you have something a little bit more concrete than they used a lesser listing to find the answer. What is your reasoning that this claim should be overturned? And I understand that you believe you're severe. I get that. But let me ask you a little bit about you said 14.06 was what they used for you. What was the actual medical condition again that you were saying, was considered for listing level criteria?
Hypermobile Ehlers-Danlos syndrome.
Okay, so give the audience just a quick description of what that is and how it limits you.
It's a connective tissue disorder where all of the tissues that hold my skeletal structure together are very, very loose, and my joints are constantly subluxing, which means they slip in and out of place. My bones are grinding against bones with all of my movements. The pain becomes overwhelming from simply being upright, even just sitting upright, very quickly.
And what about the lung issue?
The lung issue?
Yeah, with basically difficulty with breathing as a result of musculoskeletal function issues. When you breathe, do you feel pain?
Yes, but that increases in severity along with the rest of my pain from being upright prolonged periods. It's like my muscles overcompensate for the loose tissues, and then I become stiffer and stiffer, and difficulty breathing becomes a side effect of that.
Gotcha. Okay. So, all right, just to kind of simplify this down, some basic questions. As a result of this, do you medically have somebody that will come to the house, dress you, basically prepare food for you, stuff like that?
No.
Do you have a walker, rollator, wheelchair, cane, crutch, or anything like that that you use for ambulation?
Yes.
Okay, what do you use and who? Yeah, go ahead, cane. So do you have a single cane or double cane?
It's a single cane.
Okay, so with that said, when it comes for you to be able to stand, how long can you stand in the upright position for before you have to sit down or lay down?
About 25, 30 minutes.
Okay, and then what happens after 20 to 35 minutes?
I become pretty much immobilized from being upright. I have to lay down.
Okay, so you got to lay down. How long do you have to lay down for until the pain subsides enough to be able to go ahead and sit and or stand?
So that increases throughout the day and my activity levels. But it could be 20 minutes, and then like after so many cycles of being upright and recovering by laying down, it could be a couple of hours.
Okay. All right. So this to me sounds more like a vocational allowance. You don't sound over 50. Are you under 50?
I'm 34.
Yeah, so we're looking at listing level or vocational allowance. This claim should have been pushed forward for a vocational allowance because you're not at the severity level of listing criteria. Because remember, listing level criteria, I mean, they're really, really bad. Like they need support. They're damn near bedbound, which you sound similar to, but there's some wiggle room there on that one. Let me ask you this: when was the last time you were in the emergency room because you couldn't physically get up?
It was shortly before I applied, so over 3 years ago.
Okay. And what medications are you on now that you didn't take before as a result of that, basically hospital stay?
The hospital stay did not introduce any new medications.
Okay. So did you ultimately take any new medications, or are you just kind of at the same spot you were prior to the hospital stay?
Pretty much the same spot. I wasn't diagnosed yet at that time. No one knew what was going on. They were giving me just generic x-rays and basically told me I had a panic attack, which I knew that wasn't the case, but I couldn't advocate for myself at the time.
Okay. So just to clarify, you haven't had crisis medical treatment since before you basically filed for disability benefits?
Correct.
Okay. So do you see the issue there, why the judge would look at this and say, well, this guy's living in a bit of a bubble. He could probably do some sort of work, he's not, that kind of stuff?
Yes, I do. Now, I do have a very part-time job.
Mm-hmm.
It's heavily accommodated, and I'm at my maximum limit with that.
Okay.
So I suppose I had hoped that would show my initiative in that I'm, despite what you're saying about looking like I'm in a bubble and everything, which is true, that I'm doing everything I can within my means and power to keep on keeping on.
Final question I have for you. How much do you earn per month?
Maximum $128 per week after taxes.
Why is that your maximum?
Because my accommodations include maximum shift lengths of 2 hours and 4 shifts per week, none of them on the same day.
Why is that the maximum?
Because I tried doing it more than that before, and it was not doable for me. I almost lost my job by, pointing out from absences, but I was able to amend my arrangement.
Okay. The way I would have done this claim is not about listing level. It would have been all about vocational allowance, limitations, weightlifting, stooping, standing, pushing, pulling, crouching, kneeling, all that jazz. So I've got to go to the next caller, good sir. I will catch you a little bit later, but you have a wonderful, wonderful night, okay?
You too. Thank you, Walter.
Thank you, good sir. Thank you so much. Bye-bye.
Good night.
Good night. Okay, guys, we're going to take probably about 2 more callers. Here's the next one right here. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What happened? What happened? Here we go. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Yes. So what is how does Social Security decide whether somebody gets the continuing disability review, short form or long form?
Well, it's about medical improvement and likelihood of medical improvement and type of impairment. So let's say that you have a type of impairment that they believe is going to improve. It could be a surgery, it could be just the general nature of it, it could be medication that you're taking, and that pushes them in the direction of saying, hey, look, we need to look into this thing a little bit deeper, send the long form. So if it's something where it's like, stage 4 cancer and this thing ain't getting better, then they're not even going to send a form because, there's no magical cure. So aside from a biblical level amazing thing happening to the person, they're not getting better. They're probably going to pass away. They're not going to even send a form. So imagine horrible cancer, never going to be healed, likely die, likely pass away. Versus on the other medical side of the spectrum, you have basically an individual who is likely to improve with surgery, medical treatment, medication, therapy, whatever. They're going to get the long form.
Okay. All right. Like mine is, I believe they put me in the mine category, medical improvement not expected. So I probably will get the short form next time.
Yeah, you're probably going to be short forming it every so many years. And then basically, if you go through that so many years in a row and there's no medical breakthroughs related to your impairment, you probably won't get CDRs for a while. You probably won't get a short form after so many.
Even once every 7 years?
You could, but there are quite a few people who don't even get the short form.
Okay. All right. That's all I had.
Perfect, sir. Have a wonderful night.
You too.
Thank you. Bye-bye. Okay, let's see how quickly it takes for the next caller to call in. Let's see what we got. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hi, this is Jeannie from the Jersey Shore. I have a family member that has an autonomic nervous system dysfunction that's applying for SSI.
Okay.
They have already been approved by DHS in our state for developmental disabilities,
okay.
But they're really being challenged in their application for Social Security disability benefits.
Okay.
And they have a very dynamic disability, so they have difficulty remembering information, even like their medications and their diagnoses. So I've been listening to all of the videos that you have about preparing for the phone interviews, like with the judge. How can they prepare for that if they have difficulty remembering? And or what accommodations could they request?
So just for the people who are watching, who are kind of like in the chat section, who'll be watching the video down the line, this particular type of impairment, and you can add a little bit more onto it. These are individuals who, even with basic functions, heart rate, blood pumping, their brain doesn't function even at that subconscious level to go ahead and make the body work properly. So when it comes to memory, even in functional, like they're interacting with you, it's really difficult because even the most basic functions of the human body tend to be problematic for the brain to actually process, like literally pumping your heart. So does this person have issues to the point where their physiological capabilities are reduced because their brain isn't keeping up or doing what it needs to do to keep autonomous functions going?
Yes, that's correct. So, I mean, they have difficulty maintaining body temperature at anything under 70 degrees Fahrenheit. They have difficulty even just sitting up or standing up. So they're through DVRS being placed for work, but very part-time because the doctor had specified that they have to lay down at least every 2 hours and they have to take a break every hour. And they have to really limit how much they do. Otherwise, she'll have like an autonomic crisis where her blood pressure just starts to go out of control and she could, possibly die. So she has a live-in caregiver that provides assistance about 38 hours on the clock and then additional hours off the clock. And it's been really kind of just disconcerting going through the process of applying for SSI that they kind of disregarded all of that and sent her first 2 denials saying that they understood that she had medical difficulties, but they really felt that she could support herself 100%. So, we're following through with the appeals process, but at this point they're saying that, she would have to have the phone interview with the judge by herself without notes and trying to kind of prepare for that on like what information is going to be able to be presented. Will they have like a clear view from her testimony? I can't imagine how much more they need because they've sent like stacks of medical records, but they obviously want to have the opportunity to talk to her, and we want to make sure that she's prepared to the best extent. And like you said, the lawyers that you work with, they're not getting a lot back from the process, so we don't get a lot back from them.
So, this is how I do these. I always treat these claims in the same category of like 12.05 based low IQ, where they're not able to functionally give you answers related to what's going on in their life. So what I try to do with these is I stack a bunch of third-party testimony people. So like the person that, takes care of the person, I get them to go and give testimony to the judge. The parent of the person, I get them to go give testimony to the judge during the hearing process. I notify the judge ahead of time via motion that the person's not going to be able to give answers beyond just basic selective, simple bullet point answers. And then I basically run over and over and over with that person what the answers to the 5 most basic questions they could potentially be asked at the disability hearing are. And then I make sure they do a telephonic hearing so that they can have lists in front of them so that the judge can't see paperwork in front of them. So like, for example, what are the top 5 impairments? What are 2 symptoms/signs for each impairment? When did each impairment begin and become severe? Medication side effects, jobs that they've worked in the past 15, why can't they do the jobs like they used to? All those sorts of things are important, but ultimately, kind of like a seizure person that doesn't remember what happened during a seizure, or kind of like a low IQ person that can't really answer questions specific to their ability to complete things. I bring in a lot of third-party testimony individuals, but keep in mind, if the judge is in a hurry, you'll be like, okay, Your Honor, I want to go ahead and bring in this person. The judge will start the hearing off by saying, we're going to listen to one third-party person and go from there. And if I want to hear additional, I'll go ahead and allow that other person to present. So you just have to warn the third-party individuals that are going to potentially give testimony that they may go and give testimony, they may not give testimony.
Okay. And how soon would the judge have to be notified that they were going to try to stack those third-party testimonies?
I usually like to do it 20 to 30 days before the hearing. The sooner the better.
Okay.
But, it's one of those things where the sooner the better. You know what I mean? Like if the hearing is in a week, do it anyways. If the hearing is in 5 months, you could do it super early. But you want to go ahead and get that stuff in so that the judge knows what's going on. The other side of the coin is like, is this person mentally capable of making decisions about like what clothing they put on, what type of food they want, stuff like that?
So they can decide what type of clothes they want to put on, but if they're having like an issue with their nervous system or with any of their organs, and it's because of the way that they're dressed, you're going to have to tell them that because they're not going to just realize it on their own. Okay. And with the foods that they eat, they don't always remember the different things that they need to consume or the things that they can't consume, even to the point of like, they also have one kidney, so they can't have NSAIDs. And they'll say, I'm in pain. Can I take ibuprofen? Because they don't recognize that ibuprofen is an NSAID.
Mm-hmm.
And they don't understand that Tylenol is not. And no matter how many times you tell them, you're going to have to tell them again, and you're going to have to make sure that ibuprofen is nowhere that they can find it, because they won't remember when they look at it.
Okay, so with this type of situation, what you're really asking me is, how do you get the judge to see that this person is so mentally incapacitated that they shouldn't even be giving testimony on their own behalf, right?
I think it is really difficult because they have a college degree in art, so they can do art really well,
Mm-hmm.
but they do have that degree that they had a lot of physical and emotional and caregiving support to get through that process.
Mm-hmm.
But the court still looks at it like they have a degree. So how can you say that they're incapacitated because they were able to reach that milestone?
How long ago did they get the degree?
They got their degree about 2.5 years ago. They were diagnosed with dysautonomia about the same time. They actually have like a congenital dysautonomia that was further exacerbated by multiple traumatic brain injuries, and then even further increased after they had gotten COVID several times. So the doctor was like, we can see this all the way back in their record.
Mm-hmm.
But from the time that they became a teenager and started college, they began a serious decline. So to the point now where instead of being independent, which they had hoped when they had entered college, halfway through college, they ended up living back at home and being supported and cared for by their parents in order to finish college.
So you have a tricky problem of them achieving the thing that also caused them to barely graduate.
Yeah.
Okay. So you got a timeline issue. What are you claiming as your amended alleged onset date for the claim?
The last major accident that she had that started the decline, which was 2012.
Mm-hmm.
So at that point, she was in about 3 years of recovery from the accident, reached her maximum medical improvement,
Okay.
was discharged, but still had the ongoing issues from that, had other major medical instances, which we didn't know were related to this kind of connective tissue disorder, like the Ehlers-Danlos that the other woman spoke about. And that continued to compound, but we didn't have a diagnosis. So we were treating multiple different syndromes that in their own right didn't seem to be too severe, like Raynaud's syndrome or GERD or dysphagia and stuff like that. They were all like minor problems, but a long, long list of minor problems that were becoming moderate to becoming major, not disabling anyone individually. And then her doctor was able to tie them all together with Ehlers-Danlos and autonomic nervous system dysfunction, which then showed us that it's not just the joints that aren't working, but the organs, the nervous system itself, like you said, not being able to maintain blood pressure or cognitive function.
Okay. So, all right, this is going to take a little bit more special, work than just I can do in like a 5 to 7 minute. Go nudge your attorney more to do more and figure out which way this thing should go. If you still run into issues, you can always do the 1 hour option where you basically just pay for a 1 hour and I kind of figure out what to do to fix the claim and yada yada from there. But let me take because we're at 11 minutes now. Let me take the next caller. That'll be the last caller of the night. But see if you can get the attorney to kind of develop this thing more. If not, reach back out and we'll kind of figure out a solution. Yeah.
Okay. And would you still recommend going for the 1205?
I mean, you're going to go for whatever listing level criteria you can get. But what I'm not hearing is anything basically built in design for vocational allowance as your backup. And this is clearly a kid situation, not a, grid out situation. And the kid is currently working?
Yes, actually, they have a position right now, very part-time as an illustrator for a children's book company. and they'll be making around 12 to 1300 a month, even just working on like 2 books, which is probably a few days a week at like half time. But if we go beyond that, then we have a crisis for 2 or 3 days where they can't do anything.
This is not a good lineup. I'm just letting you know, because a little bit more and that kid's earning over SGA, and then the judge can have an easy out.
Yeah.
So, all right, work with the attorney that you've got. If things don't develop, call me. We can always do one of those 1-hour things. I can tell you how to develop it and prep it for a vocational allowance.
All right. Thank you so much.
Absolutely. Have a wonderful, wonderful night.
You too. Thanks.
Thank you. Bye-bye. Hi, this is Attorney Walter Hnot. We're going to be doing the what is going on with the phone? What is going on with the phone? Let's see. I'll just answer the next one. Here we go. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use what is going on with the phone? Guys, what's happening is I think they're calling in and I answer, and then they accidentally hit the call back button or whatever, and it kicks it. Let me see what we got. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use what is going on here? Could be somebody trying to do the scammy thingy. Hold on, let's see what we got here. That one auto hung up. It could be that somebody's just instant dialing over and over and over again. Hi, this is Attorney Walter Hnot. We are live on YouTube. Remember to use a fake name throughout this process. What is your legal question? Go ahead.
Hey, Walter, how you doing?
Very good, good sir.
Good to hear. Had a hearing in January, and the lawyer said that the testimony I gave was really good.
Mm-hmm.
The judge didn't want any questions from me. Vocational allowance was no jobs. And on the employee portal at the SSA website,
mm-hmm.
it switched from saying that the SSA has looked into your case to the judge, ALJ judge or whatever, has started looking into your case. I called the attorney, asked him what that's all about, and he said basically that the judge had picked up the case, looked at it, but then put it back down. And we're basically on just a matter of time kind of thing. Have you heard anything about that, or does that make sense?
Well, how many months have you been waiting for a decision since the decision? Like when was the hearing?
January.
So here's what happens. The writer gets it, and then the writer sets it up based on which way the judge wants to lean with this thing. If the writer ultimately comes down and says, okay, we found something else, or something else came to light, they can put down the claim and wait additional time. Is there anything in your claim that is time sensitive to medical treatment or just the flow of time that might change the outcome of your claim?
I'm not sure I understand what you mean. Are you talking about with the condition?
Like a surgery that's supposed to fix everything, or something where, there's a felony charge that just magically popped up out of nowhere. Anything like that?
No, basically the case was a time off task kind of thing.
Mm-hmm.
I have to do breathing treatments, and the middle one would interfere with work. So it's a time off task thing.
Okay, so so basically we've got January, so February, March, April, May. So we're looking at a 4-month period. I mean, usually you get a decision within 3 to 4 months. Sometimes it can take 5 to 6 months. Has anything been said to your law firm that this is not going the right direction, or something popped up where there was a problem?
No, from what he said to me, he sounded pretty confident in my testimony, and the fact that the judge didn't want to talk to me and, didn't ask any questions. The vocational came back as no job. So he acted positive, but at the same time, he was like, didn't say that, just kind of, it was going to be a matter of time. So I'm just new to this. I didn't know if maybe that would make sense to you and you could elaborate a little bit.
What's probably happening is something popped up, or the writer needed to finish some aspect of it, or the judge wanted something changed or written or modified or whatever. So the judge sent it back to the writer, and the writer will basically have to change or update some provision in it. That's realistically what's likely going on in this situation. But To be fair, I mean, it could be a number of a zillion things, but it's probably that the judge wanted something changed by the writer.
Okay, I'm 38, so could that be a thing?
Well, appeals counsel could have reached out and said, hey, there's an issue here. The judge is then sitting back and saying, how do I get this thing just pushed through? Or the judge is saying, well, it looks like we need to do another hearing. That could potentially happen.
Okay, yeah, because one of the things the attorney said is he was trying to, basically the judge might be trying to figure out how to apply the law to it because it is a time off task.
Why would the judge
writing,
not?
I guess he would say.
Why would the judge not know how to do the application of the law?
I don't know. I'm just telling you what the lawyer guy told me.
I mean, the judge and the writer do this all day, though.
Right. That's what I figured. But like he was saying is it was just a matter of time. But mainly the employee portal verbiage had changed, and that's really what I had, because I follow the portal. So when that changed, I called and said, hey, it changed. Is that a good thing or not? And he was like, you know, like I told you, everything sounds good, looks good, and it's just a matter of time. So
I would wait another 2 months, then start to worry.
And then get a hold of the lawyer and ask him what kind of time frame we need to wait until we reach out. Can you reach out at that point? How does that go?
Yeah, you can reach out. But look, this is all right. So what you're really asking me is, what signs tell the lawyer that there's a problem, and how do you get in front of that ball? So to simplify things, the attorney should log into the ERE and specifically look through the folders and see if anything new has been added, any new types of evidence, any new requests, any new things from the judge where the judge is requesting that some other specialist or person get involved with it. That stuff leads to the question of what's going on and why is the judge needing to do this? That's what you need to be worried about. If the attorney doesn't see any updates or changes in the ERE, then you should be okay.
Is that what he's talking about, that he looks up every week to check on his cases, the ERE? Is that what updates him? Because he said he can't see the employee portal like I can. He sees a report.
We can't see the employee portal, but what we see are all of the things that they do in the background with the documents. So basically, if they have a document that they upload, or a request or a notice or a motion, and they're putting it up there, or when they access the claim last, we can see all of that. But the cutesy little portal thing where it's like, boop, your toaster oven claim is ready, we don't see that. But we don't need that because we can see what they're doing literally in the back. So not in the pizza oven thing, like, when is the pizza going to be ready? That's not very accurate to begin with. What you want to know from your attorney is, has the judge requested anybody else get involved with this thing or sent out for any additional medical documentation for this claim?
Okay. You said about 2 months and then reach out?
I would say 2 months, reach out, get a decision, but you can always go back to the attorney and say, has anything been uploaded or changed in the ERE over the past 2 weeks?
ERE over the past 2 weeks. Walter, thank you so much. Have a great night, sir.
You as well, good sir. Have a wonderful night. Thank you so much. Bye-bye.
Bye-bye.
Bye-bye. Alrighty, guys, that's the last call that we're going to be doing tonight. I am super duper tired. I will catch you a little bit later. You have a wonderful, wonderful night, and we will go from there. Please take care of yourself. Be kind to yourself, and we will have a wonderful, amazing, magical time from there. Thank you so much. I will catch you later. Please remember to like and subscribe. If I helped you out tonight or you learned something from this video, please go to Google and type in disability resolution. Again, Google disability resolution. Throw some stars up in the review area. That always helps me. I love waking up to those. Also, if I couldn't answer your question in the 5 to 7 minutes that you get during this chat session, which is where I go live and answer questions about disability law for free, you do have an option where it's like a bigger thing where you can hire me for an hour. The little mini contract is in the bio below. And basically it's $250, and then I add you to my hearing calendar as its own little hearing. You get an hour, basically. I will catch you a little bit later. You have a wonderful night, and we will go from there. Thank you so much. Have fun, and we'll go from there. Thanks so much. All right. Bye-bye.